Good afternoon. I understand we are broadcasting and now live, so I'll begin. Welcome to our webinar, the first I have ever presented on the recent twin Supreme Court decisions of Morrisons and Barclays. Thank you very much for joining us. We'll be talking about these two decisions from appeals heard in November 2019, both handed down by video, as it happens, on the 1st of April 2020 by Lord Reed. And we'll look at the ramifications of these decisions in the two areas of media and employment law. And I'm joined by Gorasia and Claire Overman. I'm going to briefly introduce the cases, trying to set them in their legal context very summarily, given the relatively short period of time. And then Claire's going to deal with the media law implications. She's going to take over after about 15 minutes. And then after another 15 minutes, Paris is going to deal with the employment law issues. And then finally, we've allowed a bit of time for questions from participants. And our suggestion is that the questions are put in the chat section, whenever you like, to this Zoom call. And I will try and collate them, marshal them if I can, and then put them to Claire and Paris once they've delivered their presentations. Now, we're going to keep this strictly to an hour in total. And so we'll finish at 4 p.m. sharp, and earlier if there's nothing left to say about these two decisions, but I can't see that being a possibility. A couple of minor housekeeping points. I may have connection problems. I have had a few today, and if that happens, Claire's going to take over. She'll take over the chairing and the PowerPoint. And finally, on a housekeeping note, I'm in a home, I'm sure a lot of you are. Mine is full of children and an excited dog, and any they make an appearance either audio or in fact in person. So if that happens, I apologize in advance. So I'm going to start, as I threatened, by giving an overview of the cases. And that requires us to go back a little bit in time, not very far. And those of us who were alive in 2016 may feel like we've been here before, because on the 2nd of March, we had twin decisions in vicarious liability, much like we had in April this year. Those decisions were Cox and Ministry of Justice and Mohammed and poor old Morrison supermarket again. And it makes sense in this recap to look at those two decisions, because as you'll see, this duality at the heart of the concept of vicarious liability requires that. So we'll start with Cox, which was a case brought by catering manager, Mrs. Cox, at HMP Swansea. And she was working alongside a prisoner who accidentally injured her by dropping a sack of rice onto her back. Now, of course, the prisoner is not an employee of the Ministry of Justice, but Mrs. Cox sought damages against the Ministry of Justice as if he were, seeking to hold them liable for the prisoner's negligence. And that was the question at the heart of the appeal. Should the MOJ be liable for the negligence of a prisoner carrying out duties in the kitchen? And the more general question, of which that was an incident, is what sort of relationship has to exist between a defendant and a wrongdoer for vicarious liability to arise? And this was Lord Reed who grappled with this question in Cox, and in doing so, he went back to the decision in Christian Brothers case, which was the various claimants against Catholic Child Welfare Society, as it's less usually known. A 2012 case in which Lord Phillips tried to deal with the similar question, and in that case, he famously enunciated these 5 factors which go to the incidence of the vicarious liability relationship. and I've set them out there. There's no need to go through them because we'll come back to them. But they were used subsequently, including in the Cox case, where the result was that the MOJ should be liable, taking into account all of those 5 factors, for the accident which injured Mrs. Cox. The Lord Reed said that the approach in Christian Brothers provides a basis for identifying circumstances in which vicarious liability may in principle be imposed outside employment relationships. In essence, the wrongdoer has to carry on activities assigned to him by the defendant as an integral part of its operation and for its benefit. And the defendant must, by assigning those activities to the wrongdoer, have created a risk of his committing the tort. And Lord Reed commented the wide range of circumstances can satisfy these requirements, and they are not confined to commercial enterprises or indeed to the employment relationship, so that a prisoner working in a prison kitchen satisfies the requirements. That is the kind of relationship which ought to give rise to vicarious liability. So that was Cox. And the other side of those twin decisions was another Morrison's case, Muhammad. And in that case, the question was, should Morrison's be liable for the actions of its employee who has assaulted a customer? Now here, you'll notice the difference, that there was no real issue as to the nature of the relationship because it was an employer-employee relationship. It was the other side of the coin. The question is, given that your employee assaults a third party, should you be liable for that assault? And the first instance court and the Court of Appeal applied the close connections test, which had been established by then, and found that there was not sufficient connection between the actions in Mr. Khan assaulting the customer, and the Supreme Court disagreed. So the Supreme Court didn't change the law specifically in Mohammed. It affirmed that the correct test was the close connections test, but it reapplied it in a slightly more generous way, generous that is to the claimant. So that brings us to up to date to April of this year, where the position as established in those cases was that, sorry, I seem to have gone forward. Here we are, that the court will impose vicarious liability if 2 elements are shown. There must be a relationship between the 2 relevant persons, which makes it proper to impose vicarious liability. And there must be a sufficient connection between that relationship and the particular wrongdoing in question. And those 2 questions are to be determined, or were to be determined, according to the Cox case and the Christian Brothers case in relation to the first question, and in relation to the second by reference to Muhammad. So that's the end of the recap. And we now arrive in April this year with the first of the 2 decisions, and that is the Barclays decision. So just to give you the background, the bank required applicants to undergo a medical, and for a number of years, the person who carried out those medicals was Dr. Bates. It was alleged that in the course of conducting those examinations, he sexually assaulted quite a lot of people. 126 claimants got together to bring an action against the bank because Dr. Bates died, and they sought to say that the bank should be liable, vicariously liable for the actions of Dr. Bates in sexually assaulting them. The question is, was the bank vicariously liable for those sexual assaults? And the answer, in the end, was no. But it had been yes at first instance and on appeal, applying Christian Brothers case in light of the Cox case. But they had gone too far, said Lady Hale. Although a person can be vicariously liable for someone else's acts, who is not an employee, that is only the case if the relationship is sufficiently akin to an employment relationship. And crucially, the 5 factors or instances identified by Lord Phillips and Christian Brothers are not generally relevant unless there is any doubt about whether it is a relationship akin to an employment relationship. And in the case of Dr. Bates, he was never an employee. He was always conducting business on his own account. He was paid per patient. They came to his house, in fact, to be examined, and he could in no sense be said to have been in anything like an employment relationship with Barclays. And so the 5 incidences from Christian Brothers didn't arise. Which takes us to Morrison's, which is probably the most interesting of them all. The background is reasonably well known to most people, I think. A man called Andrew Skelton was an employee of Morrison's, so there was no issue as to whether or not this was the sort of relationship that might give rise to vicarious liability. He worked in a capacity which gave him access to the entire payroll information, which he, for his own personal reasons, pursuing a vendetta, ended up uploading onto a public file sharing website. And a number of claimants got together, all employees of Morrison's, and sought to sue their own employer for breach of statutory duty under the DPA, misuse of private information, and breach of confidence. And they sought to make Morrison's liable both on its own account as a data controller, and also as vicariously liable for the actions of Mr. Skelton. Now they failed in relation to primary liability, but succeeded at first instance and on appeal in vicarious liability. And the Supreme Court then had to determine these issues, the circumstances in which an employer is vicariously liable for wrongs committed by its employee. So that's the second of the 2 questions, because he was already an employee. And then whether vicarious liability may arise in the context of the DPA. And the answer was that Morrison's wasn't vicariously liable, so that it didn't have to decide the second question, although it did make some very heavy-hitting obiter comments in the negative about that. It found that there was no reason in principle why the duties imposed by the DPA and the same under the GDPR should not give rise to vicarious liability for an employer. And I've gone into a little detail about the reasons, but I don't want to spend too long on it because we'll run out of time. But Lord Reid was keen that this should be a corrective to what he considered to be judicial running away with the perceived permissiveness of the Mohammed decision. And he made clear that Mohammed was not intended to change the law. He referred back to a previous House of Lords decision, which he said better stated the law. And the close connection test was still the relevant test. And the question, therefore, is, was the wrongdoing sufficiently closely connected to the relationship between the employer and the employee, that relationship being defined by the duties, the scope of the field of the activities that the employee is expected to conduct? Was the wrongdoing sufficiently closely connected to that field of activities that it is fair, just, and reasonable to impose vicariity? So the DPA, it was overturned because of the finding in relation to vicarious liability, but they made the simple point that the Act itself is silent as to whether or not vicarious liability should be imposed, and that should be enough to keep the question open for it to be determined on the particular facts of any given case, and that is now the position. So just to put us in the picture, bring us up to speed, the two recent decisions have reset the law of vicarious liability in favour of defendants. They are a corrective to the more permissive decisions that have been happening in the recent years. And I would have turned this into a flowchart if I'd had a bit more time, but it goes like this now. If there is no employment relationship, start with Barclays. And Barclays asks you to consider whether the wrongdoer was acting on his own account or carrying out the wishes of his employer. If he's acting on his own account, then it is unlikely to be a relationship that will give rise to vicarious liability. But if there is doubt, it may be permissible to have regard to the Christian Brothers factors, although the first and last of those, which are the sort of very broad policy factors, have been marginalised. If the result is that the relationship is indeed akin to employment, then you can proceed to consider the Morrison's test. If there is an employment relationship, or if you successfully pass the Barclays analysis, then you look to apply the close connection test, and that is the connection between the wrongdoing alleged, or frequently even admitted, and the nature of the field of activities assigned to the wrongdoer by the defendant. And if there is sufficient closeness of connection, then it is fair, just, and reasonable to impose vicarious liability on the defendant. So with that snapshot of the decisions and how they were reached, I will hand over to Claire to deal with the media law implications.
Thank you, Jonathan. If you could just move on to the first of my slides. So the question that has been posed for Paris and I to answer is, what are the implications of these decisions in media and employment law? What is the effect that they're going to have on the landscape of vicarious liability? And that presupposes the first question, which is, of course, what is the landscape for vicarious liability in media law and employment law? We're only a couple of months on from those Supreme Court decisions, so I want to take a bit of a step back and have a look at where we currently are and where I think the ramifications of those decisions is really going to impact not just on data protection law, but on other areas of media law, focusing in particular on defamation law, privacy, and harassment. And you'll see there the 4 points that I'm just going to cover in my allotted 15 minutes. So moving to the next slide and beginning with the law of defamation. It's right to note, just as a preliminary point, that vicarious liability isn't something that comes up all that often in defamation law. And that stands to reason when one considers the types of defendants that media practitioners are often dealing with. More often than not, it may be a defendant publishing something on their own account, for instance, on their personal Twitter or Facebook account. Or alternatively, at the other end of the spectrum, we can be acting for or against media organisations, where, of course, those organisations are responsible for publication on their own account. But even if it were looked at through the prism of vicarious liability, it would be pretty uncontroversial that reporters and journalists in producing news content would be acting as employees in the course of their employment. Nonetheless, vicarious liability is something that does arise in defamation law. And the case of Monair and Wood is a really good example, and a recent example, of a case where, in fact, the full gamut of avenues, including vicarious liability, the full gamut of avenues for imposing liability was examined by Mr. Justice Nicklin. So just as a brief recap of the facts of that case, the publication that had caused all the controversy was a tweet that had been published on the Bristol UKIP party's Twitter account. And the tweet was a photo of Labour MP Sarah Champion standing with two men who, according to the tweet, were suspended child grooming taxi drivers. And one of those individuals was Mr. Munir, the claimant in this action. And there was no suggestion that there was any truth in the allegation against him that he'd been involved in child grooming. He wasn't even a taxi driver, and indeed did not even have a driving license. But the key issue for our purposes is that the claimants sought to claim against not the individual who had composed the tweet and eventually hit publish on it. He was the vice chairman of the branch, and he was a volunteer, as indeed all of the members of the Bristol UKIP branch were. The defendant in the action was Mr. Steve Wood, who was the chairman of the UKIP branch, but had nothing to do in sort of the colloquial sense with publication of the tweet. So the claimants really had to explore all of the avenues when seeking to affix Mr. Wood with responsibility for publication of the tweet. First of all, they started by going for direct publication, liability on the basis that Mr. Wood had directly participated in or authorised the publication of that tweet. And if we move on to the next slide, we can see that that was unsuccessful. And that was simply because on the facts, there was no evidence that Mr. Wood had been consulted or had had any kind of input into the publication of the tweet. We know, certainly the media practitioners among us know, that publication, as defined in its common law sense, is very broad. I mean, encompasses everybody who knowingly takes part in the publication of a libel or who authorises or ratifies publication. So that could include, for instance, even the newsagent who has copies of the newspaper on sale, which contains a defamatory article. But even applying that broad concept of responsibility for publication, the judge said there simply wasn't any evidence that he'd had any direct involvement or that he had in any way authorised publication of the tweet. So the claimants failed there. Secondly, moving on to the next slide, they tried agency. And that, according to Mr. Justice Nicklin, was a way in which they could affix responsibility for publication onto Mr. Wood. And it's a concept that doesn't often come up in defamation law, but without going into the details, at paragraphs 146 and following, there is a really useful summary from Mr. Justice Nicklin of the key authorities on that. And what was relevant here was that Mr. Langley was the person tasked as being, in effect, the spokesperson of Mr. Wood. He was the unofficial campaign manager, and the Twitter account was seen as his campaigning platform. And so it was held that on the basis of agency, Mr. Wood could be liable for publication of the tweet. Moving on then to the next head, which was vicarious liability, Mr. Justice Nicklin made clear that he wasn't coming to a final view on whether or not liability could be affixed on a vicarious basis. He did say, however, that he was initially sceptical, given the fact that these weren't individuals who were in any kind of employment relationship, or even, on its most generous interpretation, I would say, something akin to employment. The judge described them as a loose coagulation of people who simply shared a common political ideology and wished to support a political party. He acknowledged that there were some interesting points raised by the claimant, but in the end decided not to come to a concluded view. And moving on finally, just to the final way in which in defamation law, liability can be affixed to somebody who is not the composer of a defamatory statement. This is what's known as Byrne and Dean ratification. And the principle is set out there, and those media practitioners among us will remember the facts of this case, where a defamatory verse was left up on the wall of a golf club, and the golf club owners were held to be liable for leaving the publication up there when it was very straightforward for them to take it down. So the principle is set out there, and that's where a third party publishes material via a medium over which the defendant has control. The defendant can become liable if in the circumstances he can be said to have acquiesced or authorised its continued publication. And the key thing to remember here is that liability on this basis is liability as a primary publisher. That is to say, somebody who knows, if not the precise words being used, but certainly the gist of the words that have been published, and also has an ability to control its continued publication. And the significance of that is that, unlike, for instance, the news agents who may well have no knowledge of the defamatory article that's contained in a newspaper they're selling, an individual who's found liable as a primary publisher cannot rely on any kind of innocent dissemination defence. And that's, of course, as media practitioners know, contained in Section 1 of the 1996 Act. And here again, on the facts, this was an avenue which succeeded for the claimants. So on the basis of the judge's detailed factual findings, which are at 193 and following of the judgment, it was held that once his attention had been drawn by Mr. Monier to the contents of the tweet, Mr. Wood was affixed with knowledge and therefore liability in circumstances where the Twitter account was registered under his name, and he was very easily able to remove the tweet if he so wanted. So the conclusion, just on the basis of the Monier case, is really that the role of vicarious liability is fairly limited in defamation law, simply by virtue of all of these other avenues that a claimant can rely on in the appropriate circumstances to affix somebody with liability. So query how much of an impact the decisions on vicarious liability are going to have in defamation law. But I would raise, and Jonathan preempted me slightly by moving on to the slide, I would raise the issue under Section 10 of the Defamation Act 2013. And it's something that Jonathan and I had to confront in the case of Feziev and Radu, which was due to go to trial back in January this year, but settled ahead of the hearing. So it's something that was never aired, but a question that vexed us quite a lot, certainly leading up to it. And that is, how does this all interact with Section 10 of the Defamation Act 2013? Because this provision is a provision that now confines the court's jurisdiction in actions for defamation to anybody who is, or rather excludes its jurisdiction where somebody is not the author, editor or publisher of the statement complained of, unless it can be shown that it's not reasonably practicable for an action to be brought against the author, editor or publisher. Now, author, editor or publisher, as we know, are defined in Section 1 of the Defamation Act. And what we can see in Section 1.4 of the Defamation Act is that vicarious liability is preserved there. It said that employees or agents of an author, editor or publisher are in the same position as the employer or principal. But note that that's only confined to employees or agents. So were we getting into a situation where vicarious liability was being expanded outside of these relationships, we start to see a bit of a tension here, whereby the operation and the policy behind the Section 10 of the Defamation Act starts getting undermined if actually you can use vicarious liability to bring actions against people who weren't the author, editor or publisher as defined. But the tightening up of those requirements, as Jonathan has mentioned in the two cases in April, seems for the moment to have lessened the risk of this incompatibility in defamation law. And it is a relevant issue, I think, and certainly something that we were considering on the facts of Feziev, where, for instance, you've got relationships that claimants might start wanting to bring within the umbrella of vicarious liability. So an obvious example for media defendants is journalistic consortia. We're seeing more and more of these large-scale investigations, Panama Papers or Paradise Papers, just to name a couple. And it certainly seemed to us that if vicarious liability was able to start encroaching on these kinds of relationships, media defendants might really start to have problems. Fortunately, it seems that that's been postponed for now. Moving quickly on then, just to the remaining two areas, so privacy and harassment. Just a couple of words on privacy. First of all, in the Morrison's case, it's just worth remembering, as Jonathan did allude to in passing in his section, that it wasn't all about the Data Protection Act, although that certainly was the focus of the Morrison's decision. What the claimants were arguing in addition was that the terms of the Data Protection Act not only excluded vicarious liability in an action for breach of the DPA, but also in an action for misuse of private information or for breach of confidence. The first instance judge said no, and the Court of Appeal upheld that, noting perhaps a slightly pernickety pleading point, but in fact vicarious liability wasn't pleaded for breach of the DPA in the particulars of claim. The Supreme Court, though, cut through all of that and said, yes, the judges are right. The claimant's argument that the DPA imposed, in effect, a comprehensive scheme of liability for the protection of privacy rights was held to not be correct. And in fact, there was nothing, as Jonathan said, the Act was silent, and there was nothing to suggest that vicarious liability for breach of the DPA or for misuse of private information or breach of confidence had been swept away by its terms. And just the second point on privacy, just to move on to the next slide, is more of a substantive issue, which is that there are probably now decisions that, with the benefit of the court's reasoning, certainly in Morrison's, may now be decided differently. And by way of example, I refer to the case of Axon and the Ministry of Defence, a case from 2006, where the claimant was the commanding officer of the HMS Somerset, and complaints had been made against him that he had bullied junior officers. These were investigated and upheld, and he was told to disembark the ship at Gibraltar and to go home. And shortly after this had all happened, there were articles in the Sun newspaper about the matter, and it later came to light that a source within the Ministry of Defence had provided significant amounts of information to the Sun, including the information that was the subject matter of these articles. Now, on the facts of the case, which I won't go into here, it was held that there wasn't, in fact, a claim against the source in respect of her disclosures, because there was no reasonable expectation of privacy in them, given, for instance, his public role as the officer on the ship. So there was no claim in any event on the facts, but the court went on to consider obiter whether the MOD could have been held vicariously liable. And they said, and Mr. Joseph Nicol in that case said that the MOD could have been. In my view, this is a finding that would probably be different after the clarifications that we have seen from the Supreme Court in Morrison's. There was no issue that she was an employee, so we leave to one side the Barclays issue. The issue was simply whether the conduct, the disclosures were in the course of her employment. And the judge adopted a very broad approach to the nature of the source's job, and held that there was a clear and obvious connection between the disclosures and that part of her job, which required her to keep the information confidential. But significantly, at those paragraphs I've cited on the slide, there was a finding by the judge that the source, Ms. Jordan Barber, wasn't acting for the MOD's benefit, but was pursuing purely personal interests in disclosing the information. Now, remembering the facts of Morrison's, that seems to me to be highly significant, given the analogy between her conduct and the conduct of Mr. Skelton. And the Supreme Court has made clear that, far from being irrelevant, the employee's motive is now a highly significant factor. So where we have a finding here, a clear finding that the employee was acting purely for her own benefit, and more importantly, not for the benefit of her employer, I do suggest that this is probably a decision that would go the other way now. Finally, just moving on in the few minutes that I have left, just to harassment. This is, of course, an area that's familiar to both media and employment practitioners, although in the media context, what we're most often concerned with is harassment by acts of publication. And it's pretty uncontroversial in media law that, or as in any harassment law, that vicarious liability operates here. And indeed, the Supreme Court in Morrison cites the case of Madrowski and Guys and St Thomas's, which is incidentally an employment case. And of course, it pays to remember that vicarious liability is not the only way to impose liability on somebody who's not the main actor or perpetrator of the conduct. Liability can also be imposed on those who aid, abet, counsel, or procure the conduct. And just moving on to the next slide, although strictly speaking, perhaps less relevant to this talk because it's not directly an implication of the Supreme Court cases, it's just worth bearing in mind that you have to be precise when you're trying to impose liability on somebody who is not the main actor, whether that be through vicarious liability or indeed in any other way. In that case, just briefly, this was a very rare case of a claim being brought in harassment against a media organisation for its reporting. And the claimants in this case were French citizens who were originally from Cameroon, who were embroiled in a dispute with their local authority about some housing that had been provided for them. And Mr. Soubé spoke to the local press about his predicament, and that got picked up in various outlets, including the Sun newspaper, the Daily Star and the Daily Express. The harassment claim against these media outlets failed in substance, but an important issue was the extent to which the claimants had failed to properly particularise the claim, particularly as regards who knew what. The first slide demonstrates that, you know, if we do need a reminder, it's now in this case that if you're claiming against separate media organisations, you can't amalgamate the conduct of separate organisations and rely on that. You do need to distinguish between conduct, the conduct of each media organisation separately. Moving on to the next slide, the second point from the judgment is, of course, that if you're going to rely on the conduct of individuals acting for a corporate entity, such as employees, you've got to make clear who you're relying on, which individuals, and what the conduct is. In this case, where it was important to determine you know, who knew or ought to have known that the conduct amounted to harassment, it was very important to identify who, from the journalists to the editors or any other member of staff acting for the company, knew or ought to have known that the conduct amounted to harassment, and the claim simply didn't do that. A final and very interesting point just to leave us on for harassment, and in particular this case, the judge does spend a little bit of time floating the idea that where harassment concerns acts of publication, should we be reverting to the defamation style concept of responsibility for publication? And as we saw at the beginning of my section when we looked at Monir, that's a very broad concept. And the judge refers to the Australian case of Voller and Nationwide News Proprietary Limited. That was a case from last year where an Australian court held that if you operate a public Facebook page, you are responsible for publication of comments or posts on that page by members of the group that the page relates to. And so the judge here seems to be floating the idea of a much broader concept of responsibility for publication, where an organisation is sued in harassment on the basis of that publication. But that seems to be a discussion for another day, because moving on to my final slide, he holds that ultimately the conduct to be considered is, we move on to the next slide. Oh. The conduct to be considered is, in fact, the organisations allowing or facilitating those reader comments through the systems and moderation systems that they operated. And he ultimately says that whatever might be said about that and the adequacy of any moderation controls, he did not consider that to be the kind of conduct for which liability in harassment could affix. So with that, I hand you over to Paras to have a look at the employment law implications of these recent decisions.
Thank you, Claire. Good afternoon, everyone. My portion of this talk will focus on the employment implications of the Supreme Court decisions in respect of vicarious liability. Specifically, I will be looking at how the Barclays decision feeds into questions of employment status and the extent to which the Morrison's decision affects when vicarious liability will be imposed in the context of discrimination claims. Now, the slide itself that you have before you, as Jonathan's already mentioned, in Barclays, the Supreme Court was effectively grappling with the question as to the nature of the relationship required between the bank and the tortfeasor before vicarious liability could be imposed, and ultimately determined that an independent contractor could not found a basis for vicarious liability in respect of a client or end user. In Morrison's, the Supreme Court was focusing upon what level of connection did the relationship of employment have with the wrong committed by the tortfeasor, a critical element before vicarious liability can be found, and one which underpins such arguments in any forum. As is apparent, the Supreme Court decisions were dealing with vicarious liability issues in the civil courts. Proceedings in the tribunal have a slightly different approach. Turning to the next slide. As the employment practitioners among you will be aware, vicarious liability issues often arise in employment litigation, and in particular in relation to discrimination claims, which is of course a statutory tort. Despite the recent Supreme Court decisions dealing with claims brought in the civil courts as opposed to the employment tribunals, the factors set out by Jonathan earlier in this talk may well feed into how tribunals consider this issue in cases going forwards, once the tribunals start to hear substantive cases later this year. The issue of vicarious liability is of course significant in the employment sphere, given the frequency in which named respondents are involved in discrimination complaints, as well as of course whistleblowing claims, and the fact that often it will be the employer who is the best capitalized defendant to recover from. Turning to the issue of employment status on the next slide, we have effectively four categories that I'm just going to touch upon, starting with the most straightforward, i.e. an employee who works under a contract of service, and the definition of that is under section 231 of the Employment Rights Act 1996. With employees, there is no problem in establishing an employment relationship. It's all pretty straightforward. The second category are agency workers, which we'll look at in more detail in due course, but for present purposes, there is often an issue over whether there is any direct contractual relationship between the worker, him or herself, and the end user or client. Thirdly, we have workers or dependent contractors, as defined under section 233B of the Employment Rights Act and section 43K1 dealing with whistleblowing claims, as well as section 83(2)A of the Equality Act, who again, depending on the circumstances, will have a sufficiently close relationship akin to employment to provide a basis for vicarious liability, depending on the various facts. And then finally, we have the truly independent contractor who is on business on his or her own account under a contract for services, as was found in Barclays. This relationship will not provide a basis for imposing vicarious liability. Turning to the next slide. How the parties choose to label their relationship by written agreement or otherwise is not determinative of the question of employment status. It's crucial for a tribunal or court to assess the substance of the relationship between the parties in assessing the employment relationship between them. It is not uncommon, and indeed is a relatively frequent occurrence in the tribunals, for there to be sham agreements designed to conceal the reality of the situation. And a leading case in relation to the court's approach or tribunal's approach in determining the same can be found in the Supreme Court decision in Autocleanse and Belcher. Regard should be had also to paragraph 24 of the Barclays decision, where it was said, the question therefore is, as it has always been, whether the tortfeasor is carrying on business on his own account, or whether he is in a relationship akin to employment with the defendant. In assessing the nature of an employment relationship, there are a variety of factors which are relevant, such as, for instance, whether there is a regular volume of work, how an individual is remunerated, salary being indicative of employment, whereas a price per engagement may tend towards the other way, towards independent contractor status. There's also other issues such as the ability to send a substitute or the ability to refuse work, which could indicate independent contractor status, whereas personal service and an obligation to work may tend to the other way. Other factors very quickly include tax status, i.e. are they PAYE, do they account for self-assessment in terms of their tax returns, the degree of control exercised by the end user and or defendant, and who bears the economic risk in the relationship. Turning to the next slide, we get to section 109 of the Equality Act, which sets out the statutory basis on which an employer will be deemed vicariously liable. Now, there's four subheadings in relation to this section, but the first is anything done by a person in the course of A's employment, A being the person, must be treated as also done by the employer. So that generally covers employees and, as we'll see, workers. The second scenario is anything done by an agent for a principal with the authority of the principal must be treated as also done by the principal. Again, that attaches effectively to agency workers and end clients or users. Thirdly, the third subheading applies to both the first and second clause. It does not matter whether that thing is done with the employer's or principal's knowledge or approval. And then what we have in subsection 4 is the reasonable steps defense, where it is a defense for an employer if they took all reasonable steps to either stop A from doing that thing or from doing anything of that description. Now, the next slide, at section 83(2) of the Equality Act, defines employment. And its employment is meaning employment under a contract of employment, i.e. employees, a contract for employment, contract of apprenticeship, or importantly, a contract personally to do work. Now, that phrasing, contract personally to do work, encompasses worker status as well as employees. It's a broader category of individuals, including those who work personally to deliver personal service, but still excludes those truly self-employed. Now, the statutory provisions, namely that we've seen here at section 83(2) in relation to employment, as well as the preceding slide, in relation to vicarious liability generally under the Equality Act, apply to all of the following causes of action, as seen on the next slide. So they cover claims for direct discrimination, indirect discrimination, failure to make reasonable adjustments, discrimination arising from disability, harassment, and victimization. And all of them are common to all protected characteristics. So those statutory provisions in relation to vicarious liability underpin all of these causes of action under the Equality Act. We now turn to the decision of Morrison's on the next slide. And you can see that the Supreme Court decided that the approach for establishing the connection between the wrong by the tortfeasor and the employment relationship was whether it was so closely connected with acts he was authorized to do for the purposes of the liability of his employer to third parties, his wrongful disclosure may fairly and properly be regarded as done by him while acting in the ordinary course of his employment, paragraph 34. And then, of course, there's the classic distinction drawn between employees who are attempting to further their employer's business and those engaging in a frolic of their own. Now, the definition within section 109, which we've just seen for the purposes of discrimination claims on behalf of employees and workers before the tribunals, is in the course of employment, as we can see on the next slide. This is not the same test as the common law approach, but there are common similarities, as you might expect. This is borne out by the case law, and in particular a case called Jones versus Tower Boot Company Limited, where there was an explicit distinction drawn between the common law approach for vicarious liability, as per Morrison, which refers to a tort being closely connected to authorized acts from an employer, as distinct from the statutory approach for Equality Act claims under section 109(3), which doesn't require the employer's knowledge or approval. Now, in interpreting what in the course of employment means, the approach for the tribunals is to use everyday speech to ascertain whether conduct falls within this definition. This approach allows a tribunal to exercise a wider discretionary power to affix vicarious liability, which makes sense, of course, when we are considering that we're dealing with discrimination claims. An example of the divergence in approach in applying this test can be seen in the case of Stubbs, where Stubbs was sexually harassed in a pub by a colleague after her duty had finished, and the employer was held vicariously liable for his conduct. You contrast that with Sidhu, where no vicarious liability was found for a racist attack by a colleague at a social event at a theme park. In Sidhu, emphasis was put on the fact that the majority of the attendees at this social event comprised family and friends, and so it was held that the attack was not in the course of employment. Finally, the employer, of course, as we've seen, has recourse to the reasonable steps defense under section 109(4). Now we turn to agency workers. There are situations where agency workers who commit a discriminatory act can make the ultimate client or end user vicariously liable where the act is done with the authority of the client. That authority can either be express or implied, depending on the nature of the task that they are doing. And this can be seen in a statutory basis on section 109(2) of the Equality Act. The test for vicarious liability, when you assess the wording of this subsection, effectively adopts the common law test for vicarious liability as per Morrison's. The usual in the course of employment test under the Equality Act, which we've just seen, may not apply, as there is often no direct contractual relationship between the agency worker and the client or end user, the contract ordinarily being with an intermediary, i.e. the agency supplying the individual to the end client. And therefore, there is often no contract personally to do work, as is required under section 83(2)(a). The case of Keme provides an example of this approach. And this case involved racially discriminatory conduct by an employee of a subcontractor with whom Keme was working with. The claim was under the then enforced section 32(2) of the Race Relations Act 1976, which has now been superseded by the Equality Act. And in that case, Lord Justice Elias held that vicarious liability for an agent's discriminatory act is governed by common law principles, and that's at paragraph 33 of that decision. If we turn to the next slide, there was a more recent case in Nailart, where the Court of Appeal approved Lord Justice Elias's approach in Keme. And what you can see there in paragraph 42, which is set out in the slide, is that although the starting point is the statement of Lord Justice Elias in Keme, that the principal will be liable wherever the agent discriminates in the course of carrying out functions he is authorized to do, that formulation effectively equates the circumstances in which a principal may be liable for the acts of an agent with the course of employment test, governing the liability of employers for the acts of their employees. It may well extend the scope of the liability beyond what would apply at common law, but there is no reason why Parliament should not have chosen to effect such an extension in discrimination cases. Now, interestingly, whilst the Court of Appeal affirmed the approach by Lord Justice Elias in Keme, they seem to have equated the basis for agency worker vicarious liability to that of the course of employment test. Now, it probably makes little difference in reality to an outcome of an agency worker case, but it's going to be interesting to see if that dictum in Nailart is subject to any challenge in due course, because of course the distinction between the two is, in terms of the statutory definition, the requirement for the act to be authorized, not the act of discrimination, but acting in a manner which is authorized by the principal. Turning to the final slide, and with about 1 minute to go, this is an unusual matter which has come up in a case I've done, and I just want to quickly touch upon it, and it involves the applicability of the ex turpi causa defense. And the example can be seen in a case called Safeway Stores and Twigger. I've set out part of the judgment in that case on the slide, but facts very quickly. In that case, the employer had alleged that various ex-members of staff had, by their actions, made the company liable for fines for a breach of company law amounting to £10.7 million. The company tried to recover that sum from the members of staff for breach of contract, and the defendants sought to strike out those claims before the commercial court, but failed. Ultimately, at the Court of Appeal, they allowed the defendants' appeal and struck out the claims against them on the basis that the fines that were levied against the company were attributable to the undertaking itself and were not vicarious in nature. As the liability was personal to the undertaking, and accordingly, the doctrine of ex turpi causa, i.e. you can't sue on the basis of your own illegal act, applied, the purported causes of actions advanced by the employer were dismissed, and paragraph 23 set out there. So right on time. Thank you all for listening. I think it's time for the Q&A session, so I'll hand over to Jonathan. Over to you, Jonathan.
Thank you very much, Paris. We have only got 5 minutes left. I think we had anticipated we might have a bit longer, but either way, if anyone does have a question or a comment, briefly, that could be made now. I think there's a couple of ways of doing it, either by chatting to us on the chat function, or I understand there may be a Q&A function too, although I can't see that at the moment, so I'll see if I can find it. But it may be easier, therefore, to use the chat function if you have a question for any of us, and I can direct it appropriately. it may be the case that we don't have any, and given that we've only got a couple minutes before I said we had to finish, if that's right, then we can call it a day. We've only got 3 minutes left before we all turn into pumpkins. I've seen a query about slides. We will make the slides available. I may even put a few references on mine before we do so, if those would be considered helpful. And they will go up on the website. So I think rather than wait, we will wrap this up. And thanks very much for attending, all of you out there. And I hope enjoy the rest of the day. And we'll no doubt see some of you soon with in a normal course of our practices. And thanks very much to Paris and to Claire. I'll say goodbye. Thank you.